Hello and welcome to this, the first of three short episodes about the law of Praemunire. The law of what, you may well ask? But the law of Praemunire was the legislation that brought down Cardinal Wolsey. It brought about the submission of the clergy to the king's rule over the church. And it brought about the end, saved the reign of Mary, of papal authority in England. Now, Praemunire was not an old medieval law revived so Henry VIII could break from Rome and marry Anne Boleyn. No, Wolsey himself had used it against others when it suited his purpose. Praemunire was also at the centre of the Hunne affair of 1514, which so enraged the citizens of London and the wider kingdom against the clergy. Praemunire is not a particularly helpful title, is it? It does sound somewhat obscure, but it's not really. In essence, what it means is, or what it meant was, that English law was the law of the Kingdom of England, to the exclusion of all foreign interference. But if I may be so bold, it's almost impossible to properly understand the fall of Wolsey, the submission of the clergy, the break from Rome, the royal divorce, and so on, without some insight into the law of Praemunire. It's only then that it really starts to make sense. Now, once Wolsey had gone, the anti-clerics, infused by the sudden vulnerability of the church, had a free run to set about attacking and reforming it, which is what happened, plus some, with the dissolution of the monasteries on top of that. The weapon they used was the law of Praemunire, and to an extent its legal cousin, the Acts of Provisors. Now, the origins of the legislation can be traced all the way back to the reign of William I. Yes, him, William the Conqueror. So Praemunire was a law which brought about arguably the most famous or infamous period of English history. So what is its history? What is the history of the law of Praemunire? Well, let's find out. Well, according to the Oxford Concise Dictionary of the Christian Church, for example, it was the title of statutes, plural that is, designed to protect rights claimed by the English crown against encroachment by the papacy. The name can denote the statute, the offence, the writ, and the punishment. The Statute of 1353 forbade the withdrawal from England of cases which should be decided within the King's courts. The statutes, though, surprisingly, were not repealed until 1967. Let's go back, though, to the time of an altogether different Harold Godwinson. When William the Conqueror invaded England in 1066, he did so with the blessing and encouragement of the papacy. For the first 3 or 4 years, he used the support of the papacy to gain control over the conquered Anglo-Saxon population. By about 1170, however, he had subdued the resistance to his kingship, and his reliance on the papacy was much reduced, much to the annoyance of Pope Alexander II, who at the same time was increasing substantially the power and reach of the papacy all across Christendom, which somewhat ironically it had gained through an alliance with the Normans in Italy. William, however, in England was having none of the Pope's overbearing influence. He rebuffed papal designs such as attempts to take charge of appointments of senior clergy in his kingdom. William set about making his laws to keep the Pope at bay. He effectively erected a barrier to keep the papacy out of England.
and further, no bishops were allowed out of the kingdom. They were utterly forbidden to leave the country to travel to Rome. Any legate who came from Rome was only admitted to the kingdom as an envoy to the king. No legate was allowed to arrive and assume authority over the English church. The king was in charge of his church in England, and woe betide anyone who so much as considered breaking his rules. So the English church in those days belonged to the King of England and functioned within the laws of his kingdom. When William II inherited the throne, he continued in much the same vein. But when the next king, Henry I, succeeded, well, he ran into problems, beginning in the year 1102 with Pope Paschal II. A papacy burgeoning with confidence and self-importance now demanded with a decree that the Pope should appoint new bishops and other high-ranking clergy, such as abbots. That is to say, by its correct term, invest them with symbols of ecclesiastical office. Henry I was not too chuffed with this demand. In fact, he was bloody well annoyed about it. And thus, in the year 1102, began the so-called investiture controversy. An angry Henry told the Pope, in no uncertain terms, what to do with his decree. And if he didn't place it where Henry suggested, then Henry would withdraw annual payments, papal taxes, annats as they were called, such as Peter's pence, and banish the Archbishop of Canterbury from his kingdom. On top of that, renounce England's allegiance to the papacy. A foreshadow, perhaps, of Reformation legislation. Henry and the Pope did settle their differences by way of a compromise. The king signed over his right to invest bishops and abbots in the kingdom. However, the churchmen were still required to swear homage to the king for the land and building they held. Like many a compromise, neither side was really satisfied, and the sore between church and state festered. Henry devoted much time and money to the church, and Reading Abbey in particular, but his reign and his life were marred by the death of his only son and heir, William Adelin, who famously drowned in the White Ship disaster in 1120. As a consequence, when Henry I died, so began a long, bloody, violent war of succession. England was plunged into a civil war. The two claimants were Henry's daughter, Matilda, and his nephew, Stephen. The anarchy, as the period is known, was 19 years when Christ and his saints slept, and was one of the bloodiest, mean, most vicious times in England's history. It was a time, because of the weakness of its leader, a time when the papacy gained a powerful hold in the kingdom. The royal monopoly over the church was broken. King Stephen, for example, acknowledged many of the gains the church had made in England. He went so far as to grant a charter in 1136, just a year after his accession, which formally recognised the exclusive competence of the ecclesiastical courts in cases involving clergymen and lawsuits concerning the property of the clergy. Thus, the barrier that William I had erected to resist papal intervention just 70 years earlier was trodden down. When the war eventually came to an end, Eustace de Boulogne, Stephen's son, had claimed the throne of England for himself, but he was defeated, and the next king was Henry II. He, with passion, zeal, and vigour, attempted to restore royal control over the church. The practices that he inherited from the previous reign were intolerable. Lawlessness among the clergy, unpunished crime, misapplication of criminal immunities, and so on and so on. They were all part of the general disorder within the realm. In 1164, he took the bull, both papal and otherwise, by the horns and published the Constitutions of Clarendon. The constitutions were composed of 16 articles and represented his attempt to curtail ecclesiastical privileges, control the power of the church courts, and re-erect the conqueror's barrier to keep an overmighty papacy out of his kingdom. The articles began by stating that in the year 1164, from the incarnation of our Lord, in the 4th year of the papacy of Alexander, and in the 10th year, most illustrious King of the English, Henry II, in the presence of that same king, this memorandum or inquest was made of some part of the customs and liberties and dignities of his predecessors. For example, of King Henry, his grandfather, and others, which ought to be observed and kept in the kingdom. And on account of dissensions and discords which had arisen between the clergy and the justices of the Lord King and the barons of the kingdom concerning the customs and dignities, this inquest was made in the presence of the archbishops and bishops and clergy and counts and barons and chiefs of the kingdom. And these customs, recognised by the archbishops and the bishops and the counts and the barons and by the nobler ones and the elders of the kingdom. And then the document went on to list many chiefs and many nobles of the kingdom, clergy as well as laity, followed by the 16 articles containing the customs and dignities of the king's forefathers that ought to be observed and kept within the kingdom. The 16 articles, then, reclaimed most of the power and authority back from the church to his own royal control. But the constitutions were also framed to deal with the issue of so-called criminal clerks, or clergy who had been accused of committing a serious secular crime, but controversially, to the outrage of many, were tried in the ecclesiastical courts by benefit of clergy. The benefit of clergy, for example, entitled a clerk charged with a felony by pleading his clergy in a lay court, obtain an order for his case to be transferred out of the civil court into the ecclesiastical court of the bishop. The clergy, it was claimed, by the clergy, should not be judged by laymen, but only by their own judges according to ecclesiastical law. However, in the church court, in the case of, say, murder, the defendant would expect to receive a much lighter sentence than probably mutilation or execution than he could expect to receive in a secular court. Although a privilege, benefit of clergy became to be deemed as a clerical entitlement. However, notoriously, famously, and infamously, the Archbishop of Canterbury, Thomas Becket's vigorous, loud, tenacious objections to these 16 articles ended only when he was murdered in his own cathedral in 1170. Thomas Becket, to this day, remains one of the most famous names in English history. But what were the ramifications for English history itself? What were the consequences for Henry II, and how did it affect the Church in England? Well, find out in the following episodes of Praemunire, the law that brought down Wolsey, the clergy, and the Church.